Concrete Build presents The Future of Legal Interpreting: How AI plus Human Hybrid Systems Transform Case Speed, Client Trust, and Firm Efficiency. Chapter 1. The Language Gaps. Quietly Putting Your Cases at Risk. The hallway outside the immigration courtroom was already crowded when Alicia arrived. It was a busy master calendar morning at Herrera Immigration Group. The docket was full. Several clients spoke little or no English. Some were with family members. Some stood alone, holding envelopes and notices they did not fully understand. Luis, the senior paralegal, stood near the check-in desk with his phone in his hand. He kept glancing at the clock on the wall. The interpreter vendor had promised to send a Spanish interpreter for the morning block. The start time was getting closer. The interpreter was nowhere to be seen. Alicia tried to focus on her file. She also watched her clients out of the corner of her eye. Maria, one of her long-term clients, was seated near the wall with her young son. She had a hearing notice in her hand. She kept looking back and forth between the notice and the courtroom door. Luis pulled the phone from his ear and shook his head. "They are running behind," he said quietly. "They are trying to see if someone can get here in the next 30 minutes. Alicia looked at the time again. The judge was known for moving quickly. If cases were not ready, they were often pushed. A simple delay could set a case back weeks or months. Sometimes it meant losing a preferred hearing date. Sometimes it meant losing momentum with evidence or witnesses. "Ask them if they can patch in someone by phone until the interpreter arrives," Alicia said. "I already did," Luis replied. "They said they will call me back." He stepped aside to answer another call from the office. A staff member was asking about a different client who had just arrived and did not understand where to go. That client's cousin was translating in the lobby. The cousin was mixing legal terms with everyday language. The staff member was not sure the client understood which documents needed to be signed. Inside the courtroom, the clerk opened the door and called for counsel to check in. Alicia felt the familiar tension. She had prepared the legal arguments. She knew the facts. She trusted her team. But once again, the weakest link was language. If the interpreter did not arrive, she would have to ask for more time. If a phone interpreter was rushed into place, there could be confusion with names, dates, or instructions. If the court decided to move forward with limited support, she would have to make hard choices about what to cover and what to postpone. None of this had anything to do with the merits of the case. It had nothing to do with the strength of the legal arguments. It was all about access to clear communication in the right language at the right moment. Back at the office, the phones kept ringing. The receptionist answered a call from an anxious spouse who did not speak English. She passed the phone to Luis, who used his own working Spanish to try to explain what the notice from the government meant. He did his best. He still knew that he was not a trained interpreter. He focused on the basics and hoped that nothing critical was left out. In another room, an intern was watching a client video call. The client needed help filling out a form. The family had asked a bilingual teenage relative to sit in and translate. The relative understood general ideas, but not all legal terms. Some questions were shortened or paraphrased. The client kept nodding and saying yes. None of this would show up in the case management system as a problem. The notes would show that the form was completed and the client had been assisted. The calendar would show that the hearing had been continued or that the matter had moved forward. There was no obvious red flag. Yet in the background, gaps were opening. Similar scenes played out at Griffin Injury Law and Northside Defense and Trial. At Griffin Injury Law, Brianna took a call from Ahmed, an Arabic-speaking client who had been in a car accident. The firm had a relationship with a phone interpreting line. On busy days, wait times to connect could stretch into many minutes. Brianna put Ahmed on hold and dialed the vendor. When she finally reached an interpreter, she had only a short window before Mark finished with another client and joined the call. They rushed through insurance questions, medical updates, and instructions about treatment. Ahmed sounded polite and cooperative. When the call ended, Brianna was not sure whether he understood which documents he needed to bring to the next appointment or how the firm would communicate with him going forward. At Northside Defense and Trial, Tasha juggled calls from the jail, staff requests, and last-minute scheduling changes. When language came up, she often reached for whatever option was available at that moment. Sometimes it was a remote interpreter. Sometimes it was a bilingual staff member from another department. Sometimes it was a family member on speakerphone. No one in the office felt good about this approach. They knew it was not ideal. They also did not see a clear alternative that fit the unpredictable nature of criminal defense work. These are language gaps. They are not as obvious as not having an interpreter at all. They are the small breaks and workarounds that happen every day when the firm does not have a reliable, immediate way to handle language. A hearing that is delayed because the interpreter is late or missing is a visible problem. Everyone feels it. Everyone sees the cost in real time. But many gaps are quiet. A client signs a document they do not fully understand, but does not say anything. A family member translates, adding or removing details without realizing it. A paralegal gives a rough explanation in a second language and moves on to the next task. A jail call leaves both the client and the attorney unsure whether instructions were fully clear. Each moment can seem small in isolation. Over weeks and months, they add up to real risk. If you look at your own firm, you can probably name at least a few patterns. There are the clear delays, hearings rescheduled because interpreting was not in place, depositions pushed because no one could confirm an interpreter, intake appointments that had to be moved when a vendor could not provide coverage. There are the hidden costs in staff time, paralegals spending part of each day coordinating interpreters instead of working on cases, assistants calling and emailing vendors to confirm times, languages, and platforms, attorneys stepping in to handle language work themselves because no one else is available. Even if your team only loses a few hours per week to these issues, the impact is significant. Imagine 2 or 3 hours per week per attorney chasing language solutions. Multiply that across a month, that becomes 8 to 12 hours. Multiply that across a year. That is weeks of lost time that could have been spent on strategy, writing, or client development. Now think about direct spending. Many small and mid-sized firms already spend somewhere between $500 and $5,000 per month on language access. That may include phone interpreting contracts, freelance interpreters, and last-minute emergency calls. It can also include hidden costs, like paying staff overtime when delays push work into evenings and weekends. If that same money is stretched across inconsistent coverage, delays, and ad hoc solutions, the value is uneven. Some cases get good support. Others do not. The risk is not only financial. When clients do not fully understand, they hesitate. They may refuse reasonable offers because they are afraid. They may accept unfair outcomes because they think they have no choice. They may lose trust in the firm if they feel confused after meetings, even if everyone in the office is working hard on their behalf. A few outcomes that grow out of language gaps. A client misses a deadline because instructions were not clear. A plea is later questioned because the client claims they did not understand. A complaint is filed about communication, even though the legal work was solid. A referral source stops sending cases because their contacts feel lost in the process. None of these are theoretical. They are common enough that many attorneys can recall at least one case where language was a factor in a negative outcome, even if it was never written down in those exact words. Language leaks do not go into the file as a separate line item. The case record mentions motions, filings, hearings, and outcomes. It rarely shows the missed calls, the half-explained letters, or the conversations that relied on untrained interpreters. Still, those gaps shape what happens. Alicia has seen clients agree to dates without understanding what they mean. She has seen families leave the courthouse without knowing what the next step is. She has seen relief on their faces when someone finally explains things clearly in their own language. Mark has watched injured clients nod and stay quiet because they did not want to slow things down or seem difficult. He has seen them later admit that they were confused about treatment plans or settlement numbers. Daniel has heard clients in custody try to piece together legal terms from television and friends because they had never heard a full explanation in their own language. This is the core issue. The firm does not just need interpreters. It needs a way to make sure that every time language becomes a barrier, there is a fast, reliable, compliant way through it. A hybrid AI plus human interpreting and translation system is one category of solution that is starting to change this. At a high level, it means that your team has instant access to AI interpreters for basic explanations and simple interactions. They can tap to bring in a vetted human legal interpreter when the stakes are higher or the situation is more complex. Transcripts, summaries, and logs can be tied directly to case records instead of scattered across emails, paper notes, and separate vendor systems. Document translation can follow the same path, rather than being a completely separate process with separate tools and contacts. The idea is simple. Anytime language becomes an issue, the team uses one consistent system. They do not have to ask who to call, which vendor is on duty, or whether a bilingual staff member is available. They do not have to choose between delay and risk. They simply initiate support and move forward. Consider the before and after snapshots. Before. At Herrera Immigration Group, master calendar days feel fragile. Alicia and Luis worry about whether interpreters will arrive in time. Staff improvise with family members and partial translations. Clients leave the building with more questions than answers. After a hybrid system is in place, the team can initiate language support immediately for intake, hearings, and follow-up calls. Delays from vendor scheduling drop. Client explanations are more consistent. Notes from interpreted conversations are easier to find and review. Before, at Griffin Injury Law, Brianna spends a portion of each day on hold with vendors. Mark does not always know which conversations were interpreted and which relied on family members. Clients wait for returned calls in their own language. After a hybrid system, basic updates can happen faster. Key conversations can be escalated to trained human interpreters. The firm has a clearer view of when language was used and how it affected the timeline. Before, at Northside Defense and Trial, jail calls and emergencies push staff into rushed, stressful decisions about interpreting. Coverage depends on who happens to be available. Notes from those calls are scattered and incomplete. After, attorneys can access language support around the clock. They can set clear rules for when AI is allowed and when only human interpreters are used. Summaries of important calls are stored with the case file instead of in a personal notebook. The idea of closing language gaps is straightforward. The reality inside a legal practice is nuanced and high risk. Not every conversation can rely on automation. Not every interpreter understands the specific needs of immigration, injury, or defense work. Confidentiality, privilege, and ethical duties shape what is acceptable and what is not. Designing language access that actually fits a real firm means thinking carefully about which scenarios are low risk and can move quickly, which scenarios require trained human interpreters every time, how staff should trigger support without confusion, how logs, transcripts, and translations should be stored and secured. Most firms do not want to become architects of language technology. They do not want to manage complex workflows, guardrails, and integrations on their own. They want language access that works quietly in the background and reduces risk instead of adding new risk. The rest of this book will show how hybrid AI plus human systems, when designed for legal work, can move a firm from constant scrambling to calmer, more controlled communication. It will not teach you how to build such a system from scratch. It will help you see why the way you handle language today may be putting your cases at risk in ways that never show up on a simple report, and what is possible when those gaps are finally closed. Chapter 2. Inside the Multilingual Client Meeting. Why Speed and Clarity Decide Everything. Maria sat at the edge of the chair in the small conference room at Griffin Injury Law. She held a packet of papers in her hands. The top page showed a settlement number. The rest of the pages were forms and releases. The words were in English. She could pick out a few terms. Most of it felt distant. Her case had started many months earlier. She had been in a serious car accident. Her car was totaled. She missed work. She had pain that came and went in sharp waves. Griffin Injury Law had taken her case on a contingency fee. She trusted them. Still, this meeting felt heavy. Brianna had greeted her in the lobby and brought her back. She spoke a little Spanish. She tried to make small talk to put Maria at ease. The plan was simple. The adjuster had finally come back with a serious offer. Mark, the partner, would explain the options. An interpreter would help with details. Maria would decide whether to accept or hold out for more. That was the plan. In reality, Mark was running behind from a late call with another client. The interpreter was on another line finishing a previous appointment. Brianna checked the time again and looked at the phone on the table. "Maria, the lawyer is just finishing another meeting," she said slowly in English, then repeated it in her careful Spanish. "He will join us soon." Maria nodded and smiled. She did not want to seem impatient. She looked down at the top page again. She saw the amount that would go to her. She did not fully understand what was being deducted for fees, medical bills, and liens. She did not know what would happen if she said no. The door opened. Mark stepped in, apologized for the delay, and sat down. He looked tired. It had been a long week. He greeted Maria warmly. He asked Brianna whether the interpreter was on. "Not yet," Brianna said. "They said a few more minutes." Mark looked at his notes. The offer was reasonable. In his judgment, it was not perfect, but it was fair given the liability questions and the medical records. He did not want to rush. He also had another client waiting. "Let us at least start," he said. "We will bring the interpreter in as soon as they are free." He went over the offer in English. He spoke more slowly than usual. Brianna added short Spanish phrases when she could. Maria listened and watched his face. She caught pieces of meaning. She also felt pressure to keep up. When the interpreter finally joined by phone, they had limited time left. The interpreter's connection was slightly delayed. Mark summarized again. The interpreter translated. Maria nodded. She asked a few questions. Some were answered clearly. Others were condensed to keep the call moving. At the end of the meeting, Maria signed the release. She walked out with Brianna, who assured her that the firm would handle the rest. Maria believed that they would. She also carried a quiet uncertainty about whether she had just agreed to the best possible outcome or something less. From the firm's side, the box was checked. Settlement offer explained. Client consent documented. Release executed. From Maria's side, the experience had been something different. She had tried not to slow anything down. She had nodded when she was unsure. She had filled in gaps with her own guesses. Maria's behavior is not unusual. Many multilingual clients do not want to admit that they are confused. They do not want to feel foolish. They do not want to irritate the attorney or staff. They may assume that the firm is busy and that they should not ask too many questions. They also rely heavily on nonverbal cues. If the attorney seems confident and relaxed, they assume things are fine. If the meeting moves quickly, they assume that is how it is supposed to be. If everyone else in the room seems comfortable, they try to match that energy. When there is no interpreter present at the start of the meeting, they do not always say anything. When the interpreter arrives late and time is short, they may feel that they miss their chance to ask basic questions. Some clients will lean on family members to fill in the gaps. A spouse, child, or cousin may attend the meeting or join by phone. That family member may speak better English. They may feel pressure to be the bridge between the client and the firm. They may simplify details, soften bad news, or push the client toward a particular choice without fully explaining alternatives. None of this is malicious. It is simply what happens when there is no immediate, structured way to give the client information in their own language, at the exact moment when they need it. From the firm's perspective, these meetings can feel routine. Settlement consultations happen every week. Plea discussions are common. Case updates are part of the job. If the outcome is reasonable, the legal team may not look closely at the communication process behind it. But in every multilingual client meeting, two forces are at work. The first is legal analysis. The attorney weighs liability, damages, evidence, and risk. They compare possible outcomes. They consider the cost of delay and the likelihood of success at trial or at a later stage. They think in terms of options, trade-offs, and strategy. The second is language clarity. The client tries to understand what is being said, what is being offered, and what the consequences will be. They try to match the attorney's explanation to their own mental model of the case. They try to make a decision that protects their family. When there is a gap between these two, risk appears. A client may accept a settlement that they feel unhappy with later, claiming they did not understand. A client may reject a fair offer and push the case forward without understanding the downside. A client may agree on the surface but fail to follow through on required steps because they did not fully grasp the instructions. In multilingual settings, these gaps are more likely, not less. Speed plays a bigger role than most firms realize. Imagine a client who receives a letter in English that they cannot read. They feel anxious. They call the firm. The receptionist tries to find someone who speaks their language. If no one is available right away, the client may be told that someone will call them back later with an explanation. In that gap between concern and response, doubts grow. The client may call friends or family instead. They may post in a community group asking for help. They may seek out another attorney who can explain things faster in their own language. Even if they stay with the firm, their trust is shaken. Now imagine a different scenario. The client calls. The receptionist sees that the client has a language flag in the case file. She taps into a language access system. Within moments, an AI interpreter is active on the line. The staff member can give a simple explanation. We received a letter. It is not a denial. It is asking for more information. We will review it and call you back soon. You do not need to panic. The client hears this in their own language right away. Their anxiety drops. They know what will happen next. They stay engaged. Later, when the attorney is ready to discuss the details and strategy, the conversation can be escalated to a trained human interpreter. The early use of AI did not replace careful legal counseling. It simply bought time, protected trust, and prevented the client from sitting in fear. The key difference is speed. The firm that can explain things in the client's language almost immediately holds a strong advantage, not just in marketing terms, but in the real day-to-day work of moving cases forward. Clarity is just as important. Even with an interpreter, clarity is not automatic. The way the firm structures interpreted conversations matters. Without a system, interpreted meetings often feel improvised. The attorney speaks for a long stretch. The interpreter tries to keep up. The client listens and nods. At the end, the attorney asks, "Do you understand?" The client says yes. The meeting ends. This pattern is fragile. The client may not know what questions to ask. They may not have the confidence to say that they did not understand. They may remember only the emotional tone of the meeting, not the details. A better pattern, which hybrid systems can support, looks different. The attorney breaks explanations into smaller blocks. The interpreter, whether AI or human, gives clear, concise versions in the client's language. The attorney checks understanding with simple questions, not just, "Do you understand?" The key points and client responses are captured in a short summary attached to the case record. When a system is in place, this does not require more effort. It simply becomes the normal way to handle multilingual meetings. At Griffin Injury Law, the team did not think of themselves as slow. They prided themselves on being responsive. They called clients back. They scheduled meetings. They checked on treatment. Still, when Brianna took a step back and reviewed their multilingual cases, a pattern emerged. Clients who spoke English well tended to make decisions faster. They scheduled fewer clarification calls. They were more confident in settlement discussions. Clients who needed interpreters often took longer. They asked for extra time to think. They postponed decisions. They brought in family members to future meetings. The differences were not about culture or personality. They were mainly about how fast and how clearly the firm could explain things in the client's own language when it mattered most. When the gap between question and explanation stretched out, cases slowed. When the explanation itself was partial or rushed, trust eroded. A hybrid AI plus human interpreting system changes this dynamic. The core idea is simple. For low-risk, reactive moments, such as explaining a letter, rescheduling an appointment, or answering a basic status question, the team can use instant AI interpreting. They do not need to wait for a scheduled human. They do not need to rely on bilingual staff. They can give the client a quick, accurate explanation in their language so that anxiety does not build. For higher risk moments, such as settlement discussions, plea talks, or complex strategy meetings, they can bring in a trained human interpreter through the same platform. The switch from AI to human is not a separate process. It is an escalation inside a single system. The system can then generate a short summary of what was discussed in the meeting. It can tie that summary to the case, so that when the attorney prepares for the next step, they can see which options were explained, which questions the client asked, and what the client said about their preferences. This does not replace detailed notes. It supports them. It also gives the firm something concrete if a client later claims that they were kept in the dark. From the client's perspective, the experience becomes smoother. When Maria calls with a question about her case, she does not have to wait days to hear something in Spanish. When she receives a new document, someone can explain the basic meaning right away. When she sits down for a serious conversation about settlement, the interpreter is present and focused from the start. When the meeting ends, she leaves with a clear sense of what was decided and why. From the firm's perspective, the benefits show up in the numbers. Fewer postponed meetings due to interpreter issues. Fewer repeated calls to explain the same document multiple times. Fewer stalled cases where the main reason for delay is client hesitation or confusion. Even if the firm already spends between $500 and $5,000 per month on language access, shifting that spend into a system that prioritizes speed and clarity can unlock more value. The same dollars, applied through a better process, can move cases along faster and with less friction. It is important to see that this is not about brand. In the moment when a client is scared, confused, or under pressure, they are not comparing logos. They are not thinking about who has the nicest website. They want one thing: to understand what is happening in their own language right now. The firm that can deliver that experience consistently becomes the trusted voice in that client's life. Over time, that trust shows up in referrals, reviews, and long-term relationships. In the short term, it shows up in fewer dropped calls, fewer missed appointments, and more decisive action on offers and strategy. The question for any practice that works with multilingual clients is simple. How many times in the past year has a case slowed down or gone sideways because the client did not get a fast, clear explanation in their own language at the moment they needed it? If the answer is even a few, the cost is already real. It is measured in staff hours, rescheduled meetings, and missed opportunities. It is measured in clients who move on quietly to other firms. It is measured in stress for attorneys and staff who feel the weight of these moments but lack the tools to handle them well. If every time a client hesitated, you could explain their options in their own language within minutes, how many stalled cases would move forward faster? That is the standard that hybrid AI plus human systems make possible, not as an abstract idea, but as a normal part of intake, updates, and decision meetings. For some firms, the next step will be to map out where multilingual clients get stuck most often and what those delays are costing. For others, it will be to explore how a specialized partner can help them move from improvised solutions to a stable, always-ready language access process. When you decide that you want multilingual clients to experience speed and clarity instead of delay and doubt, there are now systems built for legal work that can support that choice. Chapter 3. What a hybrid AI plus human legal interpreting system really is. Daniel first heard the phrase AI interpreting at a criminal defense conference on a rainy Thursday afternoon. He was standing at the coffee table with two other attorneys, half listening to a vendor talk about technology for law firms. Most of what he heard that day sounded like marketing, case management dashboards, smart intake forms, automated reminders. Then someone mentioned real-time interpretation using artificial intelligence. Daniel's first thought was simple and sharp. That sounds risky. In his mind, he pictured a robotic voice talking to his clients in a jail interview room. He imagined missing a nuance in a confession or a plea offer because a machine chose the wrong word. He imagined a cross-examination thrown off course by a mistranslated phrase. He shook his head and walked away from the booth. Back at Northside Defense and Trial, He ran on a different set of priorities. He wanted reliable coverage for jail calls and last-minute hearings. He wanted human backup when things got complicated. He wanted less chaos for his team, not more. If someone had asked him what kind of system he wanted for language access, he would not have said AI. He would have said something closer to this: I want something that just works. Every time. With real people behind it when I need them. For a long time, he assumed that meant more of the same. More time on the phone scheduling interpreters. More last-minute changes. More bilingual staff stepping in when the vendor could not deliver. It took a case scare to make him look closer. The case involved a young client whose first language was not English. The charges were serious. The plea offer carried years in prison. The strength of the state's evidence was not in doubt. The question was what the client understood about the choice in front of him. Daniel had done everything by the book. He used a certified human interpreter for every key meeting. He explained the offer and the risks of trial. He checked that the client understood. Weeks later, as the case moved toward a resolution, a family member called the office. They accused the firm of pushing the client into a bad plea. They said he had not understood the consequences. They threatened a complaint. Everyone at the firm felt that knot in the stomach. They pulled notes. They checked emails. They relied on their memory of the meetings. They believed they had done it right. Still, there was no detailed record of exactly what had been said in the client's language. The complaint did not turn into a formal action. The case resolved. Life moved on. But Daniel could not shake the feeling that they were too close to a line he did not want to cross again. He did not want more technology. He wanted more control. That is when he began to look again at what a modern language access system could actually be, beyond the buzzwords. A hybrid AI plus human legal interpreting system is not a robot sitting between you and your client. It is a secure, legal-grade language access layer that sits beside your existing tools and workflows. At its core, it does three simple things. It lets your team start an AI interpreter in seconds for routine, low-risk interactions. It lets you tap to bring in a vetted human legal interpreter when the stakes are higher. It generates transcripts and summaries that attach to the case record in a controlled way. Everything else is an extension of those basic capabilities. The hybrid part of the system is not about replacing humans. It is about deciding, on purpose, when speed is the priority, and when nuance and human judgment are non-negotiable. Think about the day-to-day flow in a firm like Northside Defense and Trial. Tasha, the office manager, fields calls from jails, from family members, and from clients who struggle in English. Luis at Herrera Immigration Group has a similar experience with immigration clients. Brianna at Griffin Injury Law deals with injured clients and their families who may speak Spanish or another language more comfortably than English. Not every one of these conversations carries the same level of risk. Some calls are simple and practical. A client wants to confirm the time of a hearing. A family member wants to know whether paperwork was received. A potential client wants to ask whether the firm handles a specific type of case. Other conversations are clearly high stakes. A client is deciding whether to accept a plea. An immigrant is preparing for a credible fear interview. A family is choosing whether to accept a settlement that will change their future. A hybrid system recognizes this difference in risk and supports both ends of the spectrum. For the quick, low-risk interactions, staff can initiate AI voice or text interpreting almost instantly. They do not need to schedule. They do not need to search for someone on call. They can answer simple questions in the client's language without delay. For the high-risk interactions, the same platform can bring in a vetted human legal interpreter in a controlled way. The interpreter understands legal settings. They understand the practice area. They are prepared for the weight of the conversation. The shift from AI to human is not an afterthought. It is built into the system. Under the hood, you can think of the system as having a few main components, all working together. First, there is instant AI interpreting. This can work by voice, by text, or both. A staff member or attorney starts a session. The client hears a natural voice in their own language. The system handles basic explanations, scheduling, directions, and status updates. For many firms, this reduces the need to use bilingual staff for every small call. Second, There is human takeover. At any point, or for specific categories of calls that you define in advance, the conversation can be handled by a human interpreter instead. This might be triggered by the staff member, by the attorney, or by rules built into the system. The key is that the switch is easy and immediate, not a separate scheduling process. Third, there is document translation handled through the same platform. Instead of sending documents to a separate email address or uploading them to a generic service, staff can route forms, letters, and case-related documents through the same system that handles calls. The output is linked back to the case. The same rules about which documents can be processed by AI and which must be handled by human translators can apply here too. Fourth, there is logging, transcripts, and summaries tied to case IDs. Every interpreted interaction leaves a record. That does not mean every word needs to be stored forever. It does mean that a structured summary and, when appropriate, a transcript can be linked to the case in a secure way. If a question arises later about what was explained, the firm has more than just memory to rely on. These components are not complicated to describe. The complexity lies in fitting them into the real-life patterns of a busy legal practice. Confidentiality and control are not optional in this context. They must be built into the system from the beginning. Most attorneys are wary of technology for a simple reason. They carry the risk if something goes wrong, not the vendor. A legal-grade hybrid system respects that reality. It uses encryption so that calls, texts, and documents are protected in transit and at rest. It enforces access controls so that only authorized staff can start sessions or view summaries. It respects privilege and confidentiality by limiting where data is stored and how it can be used. On top of that, the firm can set rules that govern when AI is allowed and when it is not. For example, AI may be allowed for scheduling, reminders, and simple status updates. AI may be allowed for explaining the general meaning of a government letter, with a human interpreter used later for detailed legal strategy. Only human interpreters may be used for plea discussions, settlement decisions, and sworn testimony preparation. These rules can reflect the practice area, the jurisdiction, and the risk tolerance of the partners. The point is not to hand over judgment to a machine. The point is to give the firm more tools while keeping human judgment in charge. To see how this feels in practice, return to Daniel at Northside Defense and Trial. Before the hybrid system, a late-night jail call from a client whose first language was not English might look like this. The jail calls the main line. The call is routed to whoever is on call that week. The attorney answers, while at home or in the car. They struggle through broken English, a few phrases in the client's language, and bits of help from someone in the background. Everyone hopes that enough was understood to make safe choices. After the hybrid system is in place, the same scenario looks different. The attorney answers the call. They tap into the language access system and start an AI interpreter in seconds. They get basic clarity on what the client is facing right now. If the conversation shifts into high-risk territory, they can escalate to a human interpreter through the same interface, either immediately or at the start of a scheduled follow-up. The system creates a short summary of the call and links it to the case. When the attorney returns to the office, they can see that record and build on it. The legal judgment is still the attorney's job. The system simply makes it easier to get accurate information in both directions, even at difficult hours. At Herrera Immigration Group, Luis sees the system through a different lens. His days are filled with calls from clients like Maria, who bring stacks of letters and notices they cannot read. They also bring fear. Deadlines in immigration work can be unforgiving. A misunderstanding can mean the difference between staying in the country and being forced to leave. Before the hybrid system, Luis often acted as an informal interpreter despite his other responsibilities. He would grab a bilingual staff member. He would use his own language skills. He would call their interpreter vendor and ask for someone on short notice. Each path costs time and energy. After the system is in place, the workflow changes. For simple questions about whether a letter is a denial, a request for evidence, or a routine notice, AI interpreting provides fast clarity. For detailed preparation before an asylum interview, a trained human interpreter joins through the same platform. The rules about when to use, which are clear and consistent. When Alicia reviews a case, she can see not only the legal filings and the court dates, but also a trail of key interpreted conversations. She can see what was explained to the client and when. If a complaint ever arises, the firm is not left relying only on memory and scattered notes. Griffin Injury Law experiences similar benefits. For personal injury work, settlement conversations require careful communication. Clients must understand liens, medical bills, and future risk. At the same time, there are many routine calls about appointments, paperwork, and status. A hybrid system lets the firm reserve human interpreters for the most sensitive conversations while still giving multilingual clients timely answers on everyday questions. In this way, the system does not replace human interpreters. It protects them. Instead of being pulled into every small scheduling call, human interpreters focus on the moments where cultural context, tone, and nuance matter most. Their work becomes more valuable and more focused. The firm's cost per meaningful interpreted conversation can actually improve, not worsen. When attorneys first hear about hybrid AI plus human interpreting, they often imagine a complex setup. They picture new software dashboards, complicated menus, and endless staff training. They worry that implementing such a system will pull attention away from actual casework. In reality, the basic idea is straightforward. Give your team one reliable way to get language support at the speed that the situation demands. Make it easy to start with AI for low-risk interactions and easy to bring in a human for high-risk ones. Keep a structured record of what was discussed, tied to the case, under your control. The hard part is not the concept. The hard part is fitting that concept into the messy reality of different practice areas, counties, courts, and client populations. Real firms do not operate in straight lines. They juggle urgent calls, rescheduled hearings, last-minute filings, and human emotions. They work at odd hours. They work under pressure. They work with families in crisis. Designing language access rules, workflows, and guardrails that perform under that pressure requires expertise. It requires people who understand both legal work and language services. It requires attention to confidentiality, to privilege, and to compliance. It requires a careful balance between speed, safety, and cost. Most firms do not want to become language technology architects. They want to practice law. They want language access that feels like a quiet strength in the background. They want a system that, once designed correctly, simply does its job. A hybrid AI plus human legal interpreting system is one way to reach that point, not by replacing the human relationships at the heart of lawyering, but by giving those relationships a stronger, more reliable channel across languages. Chapter 4. From Scramble and Delay to Smooth Cases, Realistic Firm Scenarios. On a Monday morning at Herrera Immigration Group, the lobby felt tense before anyone said a word. Maria sat with a folder in her lap, eyes on the clock above the reception desk. Her master calendar hearing was scheduled for later that morning. She had taken time off work. Her sister had rearranged childcare. The stakes were obvious to everyone. Luis stood behind the counter with a phone pressed to his ear. He had called the interpreter vendor 3 times in the past hour. Each time, he heard the same thing. "We are still trying to locate someone. We will call you back." Alicia walked out of her office with a stack of files under her arm. She saw the look on Luis's face and did not need to ask. "They have not confirmed anyone yet," he said quietly. "We are due at court in less than an hour," she replied. "Ask them again if they can send anyone, even by phone." He called. He waited on hold. He watched the lobby fill. A man from West Africa arrived with his wife and a plastic bag full of documents. A young couple checked in for a consultation about a student visa. 2 clients spoke softly to each other in rapid Spanish, glancing toward Maria with nervous sympathy. The vendor finally answered. "I am sorry," the coordinator said. "We have no one available on site this morning. We might be able to get someone on the line if you can wait another 30 minutes. There was no 30 minutes to spare. At court, the delay became real. The judge looked at the docket. The clerk looked at Alicia. The interpreter assigned by the court was covering another case in a different courtroom. No one could say exactly when that would end. "Counselor, we can reschedule," the judge said. "But I do not want to waste everyone's time today." Alicia felt the familiar mix of frustration and resignation. Rescheduling meant months of delay. It meant another morning where Maria would need to leave work. It meant keeping a family in limbo in a process that already moved too slowly. None of this was because the law was unclear. It was because the language support around the law had failed. Back at the office, Luis tried to catch up on the calls he had missed while chasing the interpreter. 3 voicemails from clients asking about hearing dates. 2 messages from people who wanted to become clients. A reminder from a county office about a deadline. By the time he cleared his queue, half the morning was gone. That day was not unusual. It was the pattern. When you look at a firm like Herrera Immigration Group from the outside, it appears organized. They have case management software. They have an interpreter vendor. They have bilingual staff members who can step in when needed. On paper, they have language support. In practice, their days were filled with scramble. They would schedule an interpreter for a hearing, and then confirm again and again. They would build extra time into the calendar for the inevitable delays. They would quietly pull Luis or another bilingual staff member out of focused work to handle last-minute calls. If you added up the time, it was not small. They saw roughly a few dozen clients each month who needed language support. If even 10 of those clients had hearings or key meetings requiring an interpreter, and if each event led to just 1 extra hour of staff coordination, that was 10 hours gone. Add in the time spent rescheduling, the extra calls to reassure clients, and the time spent explaining to judges and court staff why an interpreter was missing, and it was easy to reach 15 or even 20 hours each month lost to language logistics. Those hours did not show up on an invoice. They showed up as tired staff, delayed cases, and silent risk. Clients might not complain openly. They might say they understood. They might nod during meetings, even when they were unsure. The real damage appeared later, in missed deadlines, incomplete forms, or a decision made without full understanding. The firm did not have a lack of interpreters. It had a lack of control. The turning point came when one of Alicia's clients filed a complaint with a community organization. The complaint did not accuse the firm of bad faith. It accused the system around them of confusion. The client claimed she had not understood why her hearing was delayed. She believed her case had been harmed by the absence of an interpreter. She told others in her community that the firm could not be trusted to handle cases in her language. The organization reached out to Alicia for a conversation. She listened as they described how this looked from the outside. She defended the quality of the legal work. She explained the vendor failures and the reality of interpreter shortages. The facts were on her side. Still, she heard the core message. For the client, the experience had felt chaotic and unsafe. That conversation forced Alicia to ask a deeper question. If the way we handle language makes clients feel unsafe, does it matter how strong our legal arguments are? Griffin Injury Law faced a different version of the same problem. One afternoon, Brianna sat at her desk, listening to a voicemail from Ahmed, an Arabic-speaking client who had been injured in a car accident months earlier. He had been diligent about treatment. The firm had negotiated a settlement that seemed reasonable. They had explained the offer through an interpreter and sent translated documents. Now, in the voicemail, Ahmed sounded upset. He said in halting English that he had not understood something about the medical liens. He believed too much of the settlement was going to pay bills. He thought the firm had taken too much for fees. He said a cousin had looked at the paperwork and told him he was being treated unfairly. Brianna called back and tried to bridge the gap herself. She spoke slowly in English. She used simple words. She asked whether they could schedule another call with an interpreter. He agreed, but the trust was already damaged. He had gone home, talked to family, and filled in the gaps on his own. The firm's explanations had come too slowly and with too many steps in between. By the time Mark joined the next interpreted call, a large part of the conversation was not about the case facts. It was about rebuilding confidence. He did it. The case closed, but he walked away from that experience uneasy. He realized how fragile client trust becomes when language delays enter the picture. Northside Defense and Trial discovered the limits of their old approach in a courtroom hallway. Daniel had arranged for an interpreter for a critical hearing. The client was facing a serious charge. The plea on the table would change the rest of his life. Daniel had prepared thoroughly using a human interpreter in previous meetings. He felt ready. The morning of the hearing, the interpreter called Tasha from the parking lot of another courthouse. There'd been a mix-up in the schedule. 2 different coordinators had booked the same interpreter for overlapping hearings in separate buildings. "I can be there, but I will be late," the interpreter said. "How late?" Tasha asked. "At least an hour." Daniel stood outside the courtroom with his client, waiting for information. The judge's clerk told him they could hold the case for a short time, but not indefinitely. The court had a full calendar. Other cases needed to move. In the end, the hearing was reset. To outside observers, this might have looked like a small inconvenience. To Daniel, it was much more. He had to explain the delay to a client who already felt the system was stacked against him. He had to call the family and explain why they had taken time off work for nothing. He had to rework his calendar around a new hearing date. He also had to accept that he had almost no control over the basic resource that allowed him to communicate with his client. That day became his personal turning point. When each of these firms later adopted a hybrid AI plus human interpreting system, the shift did not happen as a sudden transformation. It showed up first in the smallest parts of their day. At Herrera Immigration Group, the lobby still filled with clients each morning. The difference was in how quickly staff could respond when language became a barrier. Luis no longer spent half his time chasing vendors on the phone. For simple questions, he could tap into instant language support and give clients basic clarity in their own language. For scheduled hearings, the firm worked with a human interpreter through the same system, with better visibility into coverage. When an interpreter faced an unexpected delay, there were options. A remote human interpreter could join by phone or video without waiting for a separate coordinator. AI interpreting could provide immediate, low-risk explanations while the human interpreter connected. The net effect was clear. Fewer hearings were delayed. Clients had more real-time updates in their own language. Luis reclaimed hours each week for actual casework. If you tracked the numbers, the picture was simple. Before the change, the firm might lose 15 to 20 hours each month to interpreter logistics and delays. Afterward, they brought that number down significantly. Even if they only reclaimed 10 hours each month, that was more than a full workday of focused staff time returned to the practice. Over a year, that was more than 1 full month of work. More importantly, client confidence rose. They no longer sat in the lobby guessing what was happening. They heard clear explanations in their language. When delays did occur, those delays were explained promptly and accurately. The experience felt less like chaos and more like an organized process. At Griffin Injury Law, the hybrid system changed the tone of settlement discussions. Brianna began using instant language support for everyday calls, confirming medical appointments, explaining which forms needed signatures, answering short questions about timelines. These were the moments when clients often felt lost, but did not want to bother the attorney or ask for a full interpreter session. With the new system, Brianna could give quick, clear explanations in the client's language instead of relying on a mix of English, hand gestures, and family members on speakerphone. For settlement conferences and other high-stakes conversations, the firm still used professional human interpreters. The difference was that those interpreters were now integrated into a consistent workflow. The case with Ahmed became the case that no longer happened. When the next client in a similar situation reached the settlement stage, the explanations of fees, medical liens, and net recovery were given with both speed and depth. Questions were answered in real time. If confusion lingered after the meeting, the client could call and receive a brief, accurate explanation in their own language instead of waiting days for another scheduled session. If the firm handled even 10 multilingual settlement cases each year, and if clearer communication prevented just one case from spiraling into a complaint or negative review, the impact on their reputation and referrals was substantial. Many firms spend large sums on marketing to attract new clients. Griffin Injury Law discovered that protecting client trust through better language access inside existing cases was just as powerful. Northside Defense and Trial felt the change most strongly in emergencies. The late interpreter incident taught Daniel and Tasha that depending solely on a traditional vendor model left them exposed. They still valued certified human interpreters for hearings and complex meetings. They did not abandon that. What changed was their backup and their day-to-day coverage. When a jail call came in after hours, Daniel no longer had to choose between struggling in English or waking an interpreter from sleep. He could start an AI-assisted session to gather basic information and assess urgency. If the call needed a high level of nuance, he could schedule a follow-up with a human interpreter quickly, using the same system. When an in-person interpreter could not make a hearing, the firm could often switch to a remote interpreter through the platform instead of rebooking the case entirely. It did not work every time. Courts have their own rules and preferences, but it worked often enough to significantly reduce the number of rescheduled hearings. From Tasha's perspective, the biggest change was in predictability. Before the hybrid system, her week was full of surprises. Interpreters backing out, last-minute scrambling, unexpected gaps in coverage. Afterward, she could see a clearer picture of upcoming needs, existing bookings, and available options. Her time spent in crisis mode dropped. Her time spent in planned coordination rose. If she had previously spent 8 to 10 hours each week on interpreter issues, she found that number dropping by several hours. Over a month, that was the difference between always feeling behind and finally having breathing room to improve other parts of the practice. Across these firms, the pattern was the same. Before the hybrid system, language access lived in a patchwork of vendors, favors, and improvisation. The turning point came when a delay, a complaint, or a near miss made the hidden risk impossible to ignore. Afterward, with a hybrid AI plus human interpreting system in place, the same caseload moved with less friction and less guesswork. The system did not perform magic. It did something more practical. It gave staff a faster way to respond whenever language became a barrier. It created clearer rules about when to use AI and when to use human interpreters. It produced consistent support and better records around communication. When you stack those shifts across a full calendar, the results are easy to see. Fewer hearings rescheduled, fewer clients lost in confusion, more staff time spent on legal work instead of logistics. In many small and mid-sized firms, language access is treated as a cost to be managed and a problem to be endured. These scenarios show it can become a strength instead. When language support moves from scramble to system, cases move faster, clients feel safer, and the firm operates with less risk in the background of every multilingual file. If you recognize pieces of your own office in these stories and want to explore what a smoother, safer language access system could look like in your practice, you can have a brief, focused conversation with a specialist who lives in this world every day. Use this time to map your current pain points, estimate the lost hours and hidden risks, and see what a realistic after-state could be for your firm, starting from where you are now. https cbld as .me.ai-services. Chapter 5. The 24/7 Language Desk. Calls, jail calls, and emergencies covered. By the time the call came in, everyone at Northside Defense and Trial was already tired. It was a Wednesday. The trial that day had gone longer than planned. Daniel had left the courthouse after 8:30 p.m. Tasha had stayed in the office to finish paperwork and return a few last calls. Most of the staff had gone home. The office line rang again. Tasha looked at the caller ID. It was the county jail. She answered. A correctional officer spoke in a flat tone and gave the basic details. One of Daniel's clients was asking to speak with him. The officer added one more detail. The client's English was limited. The officer said the client was very anxious and kept repeating a few words in his own language that no one understood. Tasha glanced at the time on her screen. It was almost 9 p.m. She thought about their interpreter options. Their primary interpreter vendor only guaranteed support during business hours. There was an emergency number, but in practice, it often went to voicemail after 6 p.m. Their freelance interpreters had families and other jobs. Calling one of them late at night always felt like asking for a personal favor. She put the jail on hold and called Daniel. "Do you need me to take this now?" he asked. "Yes," she said. "They say it is urgent. They also say he does not speak much English. Can we get an interpreter?" She did not answer right away. "I can try," she said. "But at this hour, it might be hard." They did what they had always done. Tasha tried the emergency number for the vendor and left a message. She texted their most reliable freelance interpreter. No answer. She tried a second one and received a polite response that they were out with family and could not take a call. Meanwhile, the jail held the line. The officer was patient at first, then started to sound impatient. "Counsel, we cannot stay on forever," he said on the next handoff. "We have other calls to monitor." Daniel had a choice. He could try to handle the call in English and hope that his client understood enough, or he could tell the client to wait until the morning, when an interpreter might be easier to arrange. Neither option felt acceptable. He knew the risks of a serious conversation without proper interpretation. He also knew what it meant to tell a person sitting in a cell to wait overnight without answers. He tried a middle path. He got on the line with the client and explained in simple English that they were working to get someone who could interpret. He asked the client to speak slowly. He repeated key phrases. He avoided any discussion of plea offers or legal strategy. He focused only on basic reassurance. When the call ended, he still was not sure what the client had actually understood. He hung up with a familiar sense of unease. Nothing catastrophic had happened. But the firm had just faced a high-stress moment with almost no language support. The vulnerability was obvious. For many criminal defense firms, this kind of scenario is common. Calls come from jails, from police stations, from family members who have just watched a loved one taken away. The timing is rarely convenient. It is early morning, late night, or at the end of an already full day. Language is often not the first thing anyone thinks about. The main questions are always, where is my client? What are the charges? What happens next? But when the client does not speak English well, those questions cannot even be asked clearly without language support. If the firm cannot reach an interpreter quickly, everything slows down. In real life, that means off-hours calls that feel unsafe because no one can be sure what was said. Messages relayed through officers or family members who are doing their best but may not use precise language. Attorneys carrying the mental weight of, "I hope I understood that correctly," into the next day. If you add up the time and stress across a month, the numbers add up. At Northside Defense and Trial, there might be only a handful of true late-night emergencies each month. But there were many more off-hours calls that were not quite emergencies, yet still important. Even if only 5 to 10 calls each month involved significant language barriers and each one took an extra 30 minutes of back and forth because of interpretation issues, that was several hours of staff time and a large amount of mental energy. More important than the hours was the nature of those moments. They were the moments when clients were most afraid, most confused, and most likely to judge whether their attorney was truly there for them. When Northside decided to adopt a hybrid AI plus human interpreting system, full coverage was one of the main goals. They did not expect that every late-night scenario would suddenly be easy. They wanted something more modest and more realistic. They wanted to make sure that whenever a call came in, at any hour, someone at the firm had a dependable way to understand and be understood. The shift showed up first with the phones. During business hours, staff began using the system for routine calls with clients who had limited English proficiency. Paralegals could start an AI-supported session to confirm court dates, explain simple paperwork, or check on basic needs. For more complex or sensitive calls, they could schedule a human interpreter through the same platform. The bigger change came after hours. Now, when the jail called, Tasha did not have to wake a freelance interpreter or gamble with a vendor voicemail. She could start an immediate AI-supported call designed for legal use and get basic clarity on what was happening. The system could help bridge the language gap enough to understand whether this was a true emergency that required a human interpreter on the line or a lower-risk issue that could wait until the morning. If the call reached a point where nuance and precision were critical, she could request a human interpreter through the same system and move into a higher level of support. The result was not perfect. There were still limits. The firm still used certified interpreters for hearings and high-stakes conferences. But the worst-case scenario of no understanding at all moved much further out of view. Daniel noticed the difference in his own stress levels. He could answer late-night calls knowing there was at least a safe first layer of language support available. He no longer had to choose between speaking in English that might not be understood or delaying contact altogether. The 24/7 language desk at Northside was not a separate physical space. It was more like a new way of treating language access as a service that was always available across all channels. There were 3 main channels where this showed up. The first was phone calls. These included jail calls, family members calling on behalf of clients, clients calling the firm directly with urgent questions. Before, coverage depended heavily on vendor schedules and personal relationships with freelance interpreters. Now, the firm could start immediate AI-supported calls for basic communication, tap an available human interpreter through the platform when needed, record secure transcripts and summaries of key calls, and attach them to the case file. This did not mean every call was long or complex. Often, the benefit was simple: being able to explain to a family member, in their own language, that a hearing had been scheduled and what the next step would be. Being able to tell a client who had just been moved to a different facility what that meant for their case. These calls used to involve multiple attempts, voicemail tags, and frustrated relatives trying to translate for each other. With the language desk in place, they became short, clear communications that could be documented and moved on from. The second channel was video and in-person communication. For scheduled arraignments, motion hearings, and client meetings at the office, Northside still preferred human interpreters. The difference was in how those resources were coordinated. Instead of juggling separate lists, emails, and text threads, Tasha could use the same system that supported phone calls to schedule, video, or in-person interpretation. If an in-person interpreter could not make it, a remote interpreter could often step in by video without changing platforms or accounts. This gave the firm more flexibility. On some days, they still needed someone physically present in the courtroom. On other days, a high-quality remote interpreter was enough. In both cases, the request, confirmation, and record-keeping happened in one place instead of scattered across inboxes and handwritten notes. The third channel was internal staff use. Paralegals, legal assistants, and even reception staff needed to engage with clients in other languages more often than anyone realized. They made reminder calls about court dates, follow-ups on documents that had not been returned, quick check-ins after hearings to make sure instructions were understood. Before the language desk, these moments were often handled through improvised English, a friend or family member on speakerphone, or the nearest bilingual staff member being pulled away from other work. Afterward, staff had a different default. If they needed to communicate something simple to a client in another language, they could start an AI-supported session themselves. They did not have to wait for Daniel. They did not have to build a separate appointment around it. If the call exposed deeper confusion or higher risk issues, they could flag the matter for a follow-up with an attorney and a human interpreter. This changed the entire feel of internal operations. It reduced the burden on bilingual staff. It gave non-bilingual staff a safe way to handle basic language needs. It kept attorneys focused on legal strategy instead of being the only bridge for every small question in another language. The real impact of a 24/7 language desk becomes clear when you look at a few simple patterns over time. At Northside, Tasha started tracking 3 basic things. First, The number of calls that used to be delayed until an interpreter could be reached, compared to the number of calls that could now be handled in real time. Second, the number of hearings rescheduled because of interpreter issues before and after the system went live. Third, the amount of time each week that she spent in urgent interpreter coordination instead of planned scheduling. The exact numbers will vary from firm to firm, but the direction was obvious. If, before the change, the firm had to delay even 3 important conversations each week because of language barriers, that meant many nervous nights for clients and many loose ends for staff to carry. After the language desk was in place, most of those conversations could move forward instead of waiting. If, over a year, the firm had even a handful of hearings pushed because of interpreter gaps, the cost in time and trust was real. Each rescheduled hearing involved staff time, court time, client time, and often lost wages or extra travel. A more reliable system reduced how often this happened. If Tasha had been spending 6 to 8 hours each week wrestling with last-minute interpreter problems, and now spent only 2 or 3 hours on that kind of work, the difference was meaningful. Those extra hours could go into improving files, supporting attorneys, or refining other office processes. The 24/7 language desk did not just change what happened at midnight. It changed the tone of the entire week. Alicia at Herrera Immigration Group and Mark at Griffin Injury Law noticed similar shifts in their own practices, even though their work was different from criminal defense. For Alicia, the key benefit was knowing that client calls from abroad or from different time zones could be handled with clearer language support, even when they came in outside the main office hours. Many immigration clients have family members overseas. They call at times that work best for them, not for the office. With a hybrid system in place, staff could use AI-supported calls for basic updates and then schedule human interpreters for detailed legal conversations. This meant fewer days where someone left a voicemail in another language that no one could understand until an interpreter heard it. For Mark and Brianna, the language desk mattered most in the late stages of injury cases. Clients would often call in the evening after talking with family about a proposed settlement. They would have new questions, new worries, and sometimes new misunderstandings. Being able to reach them with clear explanations in their own language, even after traditional business hours, helped keep those cases moving, instead of letting anxiety build overnight. In all of these firms, the pattern was the same. Calls, jail calls, and emergencies did not stop at 5 p.m. Language barriers did not pause during nights and weekends. Traditional interpreter models were never really built for this reality. A hybrid AI plus human system, designed specifically for legal work, allowed these firms to build a practical version of a 24/7 language desk without trying to turn themselves into call centers. Attorneys could still reserve human interpreters for high-stakes meetings, hearings, and complex negotiations. Staff could still rely on human judgment for sensitive matters. At the same time, they gained a new first layer of always available support that reduced guesswork and delay. The biggest change was not visible in any one event. It was visible in how the practice felt. Less dread when the jail number appeared on the screen. Less hesitation when a client with limited English called at the end of the day. Less dependence on 1 or 2 bilingual staff members to handle every language need. When language support becomes a steady, reliable presence around the clock, the firm moves from constantly reacting to finally feeling in control of communication, regardless of the hour. Chapter 6: Working Together. How AI and human interpreters share the load safely. Luis liked Mondays a little more now. At Herrera Immigration Group, Monday mornings used to mean walking into a pile of weekend messages, interpreter requests, and worried clients. There were always a few notes in the case management system that said things like, "Client called, did not fully understand hearing notice," or "left voicemail, unclear language." Now, he had something else waiting for him. He opened his screen and pulled up the language usage report from the previous week. It was simple, a list of days. Under each day, a list of moments when the firm had used language support. There were short entries. Screening call, Spanish, AI only. Appointment confirmation, Mandarin, AI only. Document reminder. Arabic. AI only. There were longer entries. Asylum preparation session. Spanish. Human interpreter. Complex waiver discussion. Arabic. Human interpreter. Credible fear interview review. Spanish. Human interpreter. He scrolled through the list and saw the pattern that had been forming over the past month. AI had taken on the quick, routine, low-risk work. Human interpreters had focused on the complex, high-stakes conversations. The week had not felt calm. Immigration work rarely did. But there was a kind of order to the chaos that had not been there before. The difference was easy to see if you compared one Monday to another. Before the hybrid system, language support looked like one giant, messy bucket. If a client spoke Spanish, someone had to decide whether to schedule a human interpreter for every touchpoint, try to handle small things with staff who spoke some Spanish, lean on family members to explain basic instructions. None of these options were efficient. Scheduling human interpreters for every small task was expensive and slow. Using bilingual staff for constant small calls pulled them away from legal work. Family members often tried to help, but they had jobs and lives of their own. Now, the firm treated language support as two different but connected layers. Fast, automated support for low-risk interactions. Deliberate, human support for high-risk interactions. Luis saw this most clearly in how intake and screening calls had changed. On Tuesday afternoon, Brianna at Griffin Injury Law called him. They had started using a similar hybrid setup after hearing Alicia describe her experience on a call between firms. "I had 3 new calls this morning in Spanish," Brianna said. "All of them just needed basic screening and scheduling. We used the AI interpreting for each one and then marked one for a detailed follow-up with a human interpreter and mark later this week. Before that, the same 3 calls would have required more juggling. Either they would have waited until a human interpreter was available, or Brianna would have tried to handle them herself with her own Spanish, or the firm would have asked family members to stay on the line to help. None of those options were ideal. With the hybrid system, the first step was clear. AI for speed and coverage at the front door. Human interpreters for the deeper conversations once the case was real. Luis could see the same pattern in the Herrera cases. Quick questions like, "When is my biometrics appointment?" Or, "Did the court reschedule my hearing?" did not need a human interpreter every time. They needed fast, accurate explanations in the client's language. Serious conversations like, "What happens if I lose my case?" or "Should we accept this offer?" still belonged with a human interpreter present. The system helped the firm draw that line. At Herrera, they used a simple rule of thumb that developed over time. AI was used when the main goal was speed. The topic was routine and low risk. The call or message was short. The main need was to confirm facts, give dates, or share simple instructions. Human interpreters were used when the stakes of the conversation were high, the topics were complex, emotional, or technical. The outcome of the conversation could change someone's life. The attorney needed nuance, tone, and cultural context to be clear. In practice, that meant AI support for things like reminder calls, status updates, basic screening questions, clarifying which documents were missing. It meant human interpreters for asylum interviews, relief strategy meetings, complex waiver discussions, conversations about risk, options, and trade-offs. The key was that both layers lived inside one system. Staff did not have to decide which phone number to dial or which platform to open. They started in one place and then moved up to human support when the situation called for it. One day, Luis went through a full week for a single client file to see how this looked over time. The case belonged to Maria, the same client Mark represented at Griffin Injury Law in her injury claim. She also had a pending immigration matter with Herrera. On Monday, she received an AI-supported call to confirm a time for her next check-in. On Wednesday, she called the firm with a worry about a notice she had received in the mail, and the staff used AI to quickly understand what the letter said and reassure her. On Friday, she had a detailed strategy meeting with Alicia and a human interpreter to talk through the next phase of her case. In the past, these 3 points of contact might have looked completely different. The confirmation call might have been done in broken English. The worry about the mail might have been delayed until an interpreter could be reached. The strategy meeting might have been rushed because of all the unresolved confusion from the earlier points of contact. Instead, the firm now used the right level of support at the right moment. Maria felt heard and informed throughout the week. Alicia walked into the strategy meeting knowing that Maria had already received clear answers on the basic questions. The human interpreter could focus on the deeper parts of the conversation instead of spending the first half of the session catching up on simple clarifications. This is what it looks like when AI and human interpreters share the load safely. Luis was not a technician. He did not care about the internal workings of the AI. He cared about what happened to his day. He noticed that the front desk was calmer. They could answer more calls without apologizing for delays in language. He noticed that bilingual staff were not pulled away as often to just hop on this quick call. They still used their language skills, but in more thoughtful ways. He noticed that human interpreters seemed less exhausted. They were still busy, but their time was used where it mattered most. Before the hybrid model, it was easy to either overuse or underuse human interpreters. Some firms tried to use them for everything and ended up with constant scheduling headaches and high costs. Other firms tried to save money by limiting interpreter usage and ended up with miscommunications and risk. The hybrid model avoided both extremes. AI picked up the routine work that did not justify a full session with a human. Human interpreters focused on the moments where their skill and presence changed the outcome. From a cost perspective, Herrera could see a shift. They did not simply spend less. In some months, total spending on language support stayed similar. In other months, it even went up. The difference was in the value for each dollar. Less money went into scrambling and waste. More money went into targeted human support that actually protected cases. The firm saw fewer last-minute interpreter emergencies. They saw fewer clients nodding along without real understanding. That was worth more than any line-item savings. Daniel at Northside Defense and Trial saw something similar from the criminal defense side. He still relied heavily on human interpreters for court, plea discussions, and sensitive jail calls. But he began to trust AI support for triage and for quick, factual exchanges. If a client's family member called to ask what the next court date was, staff could answer in the correct language without waiting on a human interpreter. If a client in custody needed to confirm a simple detail, Daniel could use AI support to get clarity and then schedule a deeper call with a human interpreter later. This did not replace the human interpreters he trusted. It gave them breathing room. Instead of saying yes to every small request, they could commit their time to the parts of the case where their expertise was irreplaceable. Law is full of conversations that are important but not all equally risky. Explaining a dress code for court is not the same as explaining a plea deal. Confirming a time is not the same as explaining the consequences of a choice. A hybrid system lets a firm respect that difference. Behind the scenes, someone has to design the rules for how this works. Which types of calls can safely start with AI? Which topics always require a human interpreter from the beginning? How should staff escalate from AI to human when a conversation becomes more complex than expected? These are not theoretical questions. If a firm wants to share the load safely, they need clear answers that everyone can follow. At Herrera, Alicia sat down with Luis and the rest of the team early on to outline simple guidelines. Over time, they refined them based on real experience. At Griffin Injury Law in Northside, similar conversations took place. The goal was not to create a rigid script that no one could adapt. It was to create a shared understanding of how AI and humans would work together, so that no one had to guess in the middle of a stressful call. This is where a platform designed for medical and legal-grade interpretation makes a difference. It is one thing to have generic AI tools. It is another thing to have a system that is built around clear logs of every interpreted interaction, summaries tied to case records, role-based access controls for staff, support for both AI and human interpreters under the same roof. Hybrid does not only mean AI plus humans. It means AI and humans working within a structure that respects confidentiality, risk levels, and the realities of legal practice. Concrete Build was built with that structure in mind. The platform is designed to support both AI interpreting and human interpreters in a way that fits the way law firms actually operate. It is not a generic call center tool. It is not a simple translation widget. It is meant to sit quietly under the work your firm already does and make your language support faster for routine needs, safer for high-stakes conversations, clearer to audit and review. When a firm like Herrera or Northside uses Concrete Build, they are not just turning on a piece of software. They are stepping into a way of working where AI and human interpreters share the load according to rules that they help define. Attorneys keep control over the most important conversations. Staff gain confidence that they can handle basic language needs without making risky decisions alone. Human interpreters are treated as high-value partners, not as a last-minute patch for every problem. The result is not flashy. It is steady. Week after week, more calls are handled on time. More clients receive explanations they actually understand. More critical conversations happen with the right people in the room, in the right language, at the right moment. When you look at your own firm, you may already see parts of this pattern. Times when you wished something faster and lighter could handle basic language tasks. Times when you wished your human interpreters were saved for the moments that really mattered. A well-designed hybrid system exists to make that wish practical. When you work with a specialist team that lives inside this world every day, you do not have to turn your firm into an experimental lab. You can adopt a structure that has been built and tested around legal risk, client trust, and staff workflows. If you want to see what this could look like in your own practice, there is a simple next step. A short call with a Concrete Build specialist can help you map where AI support would make life easier, where human interpreters should always lead, and how to put clear rules around both so your team feels safe using them. The conversation is brief, focused on your practice areas, and designed to give you clarity, not pressure. HTTPS CBLD as Me AI Services. Chapter 7. The Language Access Numbers that actually matter. Mark stood in his office at Griffin Injury Law and stared at the whiteboard. For years, the only number he tracked for language access was a single line on a monthly report. Language services, $3,000. Language services, $4,500. Language services, $2,800. Some months it felt high. Some months it felt low. None of it actually told him whether the money was doing what he needed it to do. Now, the whiteboard looked different. At the top, Brianna had written a simple list. Clients who need language support. Times language slows us down. Conversations with proper interpretation. Cases moving forward on time. Satisfied clients and referrals. Under each line, there were small notes, arrows, and examples from the past few weeks. "This is not a dashboard," Mark said, half joking. Brianna shook her head. "No, but it is the first time we can actually see what is happening instead of guessing." They had not installed a complicated analytics tool. They had done something simpler. They had started paying attention. The realization began with a single case. Ahmed, an Arabic-speaking client, had been rear-ended on the highway. His injuries were clear. Liability was clear. It should have been a straightforward personal injury matter. Instead, the case dragged. There were missed voicemails, delays in scheduling, follow-up appointments, confusion about a proposed settlement. Every time Ahmed came into the office, he seemed polite but distant. He nodded a lot. He said yes, often, but he did not sign. One afternoon, after yet another rescheduled discussion, Mark sat down with Brianna. "I feel like something is missing," he said. "This is a strong case. Why is it crawling?" Brianna hesitated. "I think he still does not fully understand his options. Even with the interpreter, there are gaps between the big conversations. He gets nervous. Then he goes home and talks to relatives who give him other advice." They realized that they had only been looking at a few big interpreted moments. The initial intake, A long meeting with an interpreter to explain medical treatment. A scheduled session to review the settlement offer. They had not been looking at what happened in between. Quick questions about letters from the insurance company. Phone calls about doctor appointments. Messages from family members who wanted to weigh in. Language was leaking at all those points. The case was not stuck because of one bad translation. It was stuck because there were too many small moments where communication was not fully clear or fully timely. That was the day they drew the first version of the visibility chain on the whiteboard. The first link was simple. Clients who need language support. Brianna pulled a rough list from their case management system based on known language preferences. Then she added notes from her own memory. They realized that in a typical month, a meaningful slice of their active caseload involved clients more comfortable in Spanish, Arabic, Vietnamese, or another language. This was the group most likely to experience friction. This was also the group most likely to refer others from their community if they felt well supported. Before, they would have looked at them as individual cases. Now, they thought of them as a group that needed a consistent experience. The second link was subtle. Times language becomes a bottleneck. At first, the team struggled to name these moments. It felt vague. So they started jotting down simple examples every time someone said, "We need to wait for the interpreter," or "We cannot move forward until we call back in their language." By the end of 2 weeks, the list was longer than anyone expected. A client waiting in the lobby while someone tried to reach an interpreter. A paralegal postponing a scheduled call because the usual interpreter was tied up. A doctor's office leaving a message in English that the client did not fully understand. A family member calling in to ask questions that staff did not feel comfortable answering in English only. These were all moments when language held up progress. None of them showed up on a traditional report. There was no line item that said 2 hearings delayed due to unclear communication, or 4 clients have not made a decision because they are still confused. But they were real. When Brianna looked at her week through this lens, she could count them. She estimated that in 1 week, she spent several hours either waiting for language support or trying to work around the lack of it. The other staff had similar stories. Multiply that by 4 weeks in a month, and the number of bottleneck moments grew quickly. No one had realized how often they were working around language instead of through it. The third link brought the issue into focus. Conversations that happen with proper interpretation. Mark started asking a new question in case review meetings. Did we have a real interpreted conversation about this yet? Or did we just exchange messages and hope they understood? It was a simple question, but it changed how they saw the file. Some matters had clear answers. Yes, we spent an hour with a human interpreter explaining the options. Others were fuzzier. We mailed the letter in English, and then the client's cousin called and said they talked about it at home. We had a quick phone call. I think they understood, but we did not use an interpreter that time. Those fuzzy answers often matched the cases that were stalled. It was not that the firm had done nothing. They had done enough to feel like they had communicated. They had not done enough to feel certain that the client truly understood and could decide. That was the difference between motion and progress. A hybrid AI plus human interpreting system helped close this gap. Fast AI support meant they could answer small questions in the client's language without waiting days. Human interpreters were still used for the key decision points. More conversations actually counted as fully interpreted, not halfway measures. Over time, Mark could see a pattern. Cases where the team made sure to have proper interpreted conversations at the right moments moved faster and with fewer surprises. Cases where they relied on partial understanding stayed stuck longer and generated more back and forth. The fourth link was where timelines showed up. Cases that move forward on time. At first glance, this seemed like a function of courts, insurance companies, and opposing counsel. It was easy to blame delays on outside forces, but when the team looked closely at their multilingual cases, they saw another layer. A hearing postponed because the client did not bring a document they did not fully understand. A demand letter held up because the client hesitated to approve it. A settlement offer sitting on a desk while the client tried to make sense of it with help from friends instead of with the firm. Language was not the only factor in these delays, but it was part of them. With the hybrid system in place, they started measuring a simple indicator. Once a decision was ready for the client, how long did it take to have a proper conversation in the client's language about it? If it took days, the case stalled. If it took hours, the case moved. AI support made it easier to reach the client quickly, even for a short explanation, or to schedule a deeper interpreted call. Human interpreters handled the conversations where a signature or a major decision was at stake. This reduced the silent lag between "we are ready" and "the client understands and has decided." They did not need a complex formula. They just needed to see how many decisions were waiting on real understanding rather than on documents sitting unread. The final link was the one every firm cares about: client satisfaction and referrals. Before, Mark measured this through reviews, occasional surveys, and the number of new clients who said they were referred by a friend or relative. He still used those methods, but he started listening more carefully to what multilingual clients actually said in those reviews and in exit conversations. When clients felt rushed or confused, they used phrases like, "I did not always understand. I had to ask my family to help explain. I was nervous to call because I did not know if someone could talk to me in my language." Admitivitor. When clients felt supported, they said things like, "They always explained everything in my language. I never felt embarrassed to ask questions. They made sure I understood before I signed anything." These comments were not about legal skill. They were about language. A clear pattern emerged. When the visibility chain was strong at each step, clients were more likely to leave positive reviews, pay their bills, and refer others. When the chain had leaks, the firm had to work harder to earn the same level of trust. The hybrid AI plus human system did not magically solve all of this. It gave the firm better tools and more consistent ways to close the gaps. With instant AI interpreting, the number of times language became a bottleneck dropped. Staff no longer had to delay every conversation until a human interpreter was available. They could answer basic questions quickly, confirm simple details, schedule deeper interpreted meetings without delay. With human interpreters anchored in the same system, the number of fully interpreted conversations at key moments rose. There was a record of what had been explained. There were summaries attached to the case file. There was less guesswork about whether the client had been properly informed. Over a few months, the team began to notice small but real shifts in the numbers they tracked informally. More multilingual clients were getting callbacks in their preferred language sooner. Fewer cases were sitting idle because someone was waiting to find a time with the interpreter. More settlement reviews and major decisions were happening in structured, interpreted conversations instead of rushed follow-ups. When Brianna pulled their language spend again, the total number did not shock anyone. It was still a few $1,000s per month. What changed was their understanding of what they were buying. They were not paying for minutes on a phone line. They were paying to strengthen each link in a chain that connected language access to case speed and client trust. Alicia at Herrera Immigration Group went through a similar exercise with Luis. For them, the visibility chain showed up most clearly in court timelines and in client preparedness. They began tracking, in a simple spreadsheet, how often language contributed to continuances, last-minute scrambles to prepare, clients arriving without key documents. They did not need perfectly accurate data. Even rough counts were enough to spot patterns. After implementing the hybrid system, they saw fewer hearings continued due to confusion, fewer missed documents, more clients who could summarize their own case back to the attorney in their own words. Luis joked that a good test was this. If I ask a client, using interpretation, "Can you tell me what you think is happening in your case right now?" and they can give a clear answer, our language support is doing its job. If they could not, there was still work to be done. Once you start seeing language access through numbers instead of just through anecdotes, the conversation in the firm changes. Staff are less likely to say, it is just how it is with clients who do not speak English. They are more likely to ask, where is the leak in the chain for this case, and how do we close it? Managing partners stop seeing language spend as a cost that should be minimized at all times. They start seeing it as an investment that can be tuned. You do not have to build complicated reports to get there. You can start with 3 simple questions. How many of our current clients prefer a language other than English when things get serious? How often does language slow us down or cause confusion in a typical week? How many of our important conversations with those clients happen with proper interpretation, with a record that we can look back on? If you can answer these questions even roughly, you have more clarity than most firms. From there, every improvement in your hybrid system has a visible effect. If more multilingual clients get timely calls in their own language, you feel it in fewer missed appointments. If more decisions are explained with full interpretation, you feel it in fewer stalled files and fewer surprises. If more notes and summaries from interpreted conversations are attached to case records, you feel it in better preparation for hearings and negotiations. Language access stops being an invisible drag on your practice and starts becoming something you manage with intent. Once you can see these numbers clearly, you stop guessing. You make choices. You decide where AI can safely speed things up. You decide where human interpreters must always be present. You decide how to measure whether those choices are working. The firms that do this do not become obsessed with metrics. They simply refuse to fly blind. They still feel the pressure of full dockets, demanding clients, and changing rules. But they no longer accept quiet language leaks as just part of the job. End quote. His Rautus and furs. They treat language like what it is, a controllable factor that, if handled well, can protect case outcomes, strengthen client trust, and free their staff to do the legal work they were actually hired to do. Chapter 8. Why Ad Hoc Solutions Break, and What a Robust System Really Requires. By 9:30 a.m., Tasha's desk at Northside Defense and Trial already looked like the center of a small call center. Her email was open with 3 different message chains from freelance interpreters. Her text messages had a list of contact names with notes like Spanish, evenings only, and Vietnamese, reliable but busy. Her desk phone had a sticky note with a jail call time scribbled across it. Her calendar had a reminder to confirm an interpreter for a plea hearing the next morning. Daniel walked in, holding a file. "We just got notice that the hearing for Lynn's case may be moved up," he said. "Can you see if we can get someone for tomorrow afternoon instead of next week?" Tasha nodded, even though she knew it meant another scramble. She opened an old spreadsheet where she kept interpreter contacts. Some numbers were crossed out. Some names had comments like last-minute cancellation or rate went up. Then her phone buzzed. The courthouse clerk needed confirmation for another matter. A freelance interpreter was asking if they would guarantee a 2-hour minimum for a short appearance. A paralegal was messaging her about a client who had arrived early and needed help right now. Tasha took a breath. She was good at her job. She could juggle all of this. She always had. But as she clicked through emails, texts, and calendar entries, something became clear. There was no single place where language access lived. It was scattered across her inbox, her memory, and a patchwork of tools the firm had outgrown years ago. The ad hoc system had not started as a system. It had grown out of good intentions and quick fixes. At first, Northside Defense and Trial had a small list of freelance interpreters for the most common languages they needed. Then, someone added a few more names. Then they tried a generic video platform for some remote matters. Then, bilingual staff started stepping in when interpreters were late or unavailable. Then, clients began bringing family members to help. Just this once. Every change made sense in the moment. None of it added up to a reliable way to handle language for a busy defense practice. When cases were simple and the calendar was light, the cracks were small. An interpreter arrived late, but the court squeezed them in. A client's cousin interpreted a meeting, and no one complained. A jail call was postponed until the morning. As the caseload grew and the stakes stayed high, The cracks widened. One afternoon, a judge called on a matter earlier than expected. The interpreter was still on another case. The backup interpreter did not answer the phone. The court offered to proceed with whoever could assist. Tasha watched Daniel weigh his options. He did not want to delay. The client had been waiting for this hearing. He did not want to proceed with someone unvetted. The plea discussion was serious. They managed to get a human interpreter on the line after a few tense minutes, but the experience shook them. Later that day, Daniel walked into Tasha's office. "We cannot keep doing this," he said. "We need to talk about how we are running language access as a firm, not just as a day-by-day scramble." Tasha looked at her notes, spreadsheets, and text threads. She knew he was right. The problem was not that they did not care about interpreters. The problem was that they were trying to hold together a fragile structure with a mix of tools and favors. They had an ad hoc solution, not a system. Ad hoc solutions usually break in the same places, even if each firm's details are different. The first weak point is rules. In Northside's case, there were no consistent, written guidelines about when to use which interpreter or which method. Sometimes they used a freelance interpreter for a short, low-risk call. Sometimes a bilingual staff member stepped in for a complex conversation because it seemed faster. Sometimes they scheduled formal court appearances through one vendor and informal meetings through another. Everyone was trying to help. Everyone was also making judgment calls on the fly. That meant the same type of conversation might be handled 3 different ways depending on who answered the phone or who was in the office. No one was looking at the whole pattern. The second weak point is records. Notes from interpreted calls lived in different places. Some interpreters sent brief summaries by email. Some calls had no written summary at all, just a quick note in the file. Sometimes staff wrote down key points, but the note stayed in their personal notepads. There was no centralized log of who interpreted what, when, and with which client. If someone needed to review what had been explained before a critical hearing, they had to piece it together. They would scan emails, ask around, or rely on memory. That was not good enough for a practice where one misunderstood phrase could change the direction of a case. The third weak point is coverage. Ad hoc setups often assume that cases will behave in neat patterns. Calls will come in during business hours. Hearings will start on time. Interpreters will be available when scheduled. Real life does not cooperate. At Northside, jail calls could come late in the evening. Family members might call on weekends. Courts sometimes moved matters with short notice. With their patchwork approach, coverage outside standard hours depended on who was willing to pick up their phone and help. Sometimes it worked. Sometimes it did not. The fourth weak point is experience. Clients can feel when the firm is improvising. They may not see all the emails and texts behind the scenes, but they can sense delays, confusion, and shifting interpreters. A client who speaks limited English is already stepping into a stressful situation. When they see different interpreters every time, or when staff seem unsure how to get language help, it adds to their anxiety. Over time, this erodes trust. Even if the legal work is strong, the overall experience feels shaky. When you add all of these weak points together, the cost is real. Even if it is hard to see on a single report, staff lose hours each week trying to coordinate interpreters, cover gaps, and fix scheduling mistakes. If a firm has a few dozen active matters involving clients who prefer another language, and each of those cases generates even 1 or 2 extra hours of coordination per month due to ad hoc systems, that becomes many lost hours. Those are hours that could have gone into case preparation, motion practice, or client counseling. Delays driven by language confusion or missed connections push hearing dates and decision points further into the future. Clients feel less confident. Attorneys feel less prepared. The firm feels like it is always reacting. All of this happens even when no obvious disaster occurs. The real problem is not a single bad day. It is an ongoing pattern where language access is fragile. A robust hybrid AI plus human system addresses these weak points in a different way. Instead of starting with a list of interpreters and a few tools, it starts with clear, firm-level rules. For example, the firm decides in advance What kinds of conversations must always have a human interpreter? High-stakes plea discussions, complex sentencing explanations, detailed reviews of rights and consequences. They also decide what kinds of interactions can safely use AI support, with human backup available. Simple appointment reminders, basic status updates, screening calls to confirm contact information. These are not casual guidelines. They are written rules that everyone can follow. When a new staff member joins, they do not have to guess. They know when to press a button for AI, when to request a human interpreter, and when to escalate. The system, in turn, is built to make those choices easy. Instant AI voice or text interpreting covers the many small, lower-risk moments that would otherwise rely on English only or not happen at all. Human interpreters are integrated into the same platform so that when a conversation reaches a higher risk point, staff can bring in a vetted interpreter without switching tools or starting from scratch. This does not remove judgment. It gives judgment a structure to work within. Records become part of the normal flow instead of an afterthought. Each interpreted interaction, whether AI-supported or human, can generate a log and a short summary. Those records can be tied to the case reference the firm already uses. Later, when Daniel prepares for a hearing, he does not have to dig through old emails and memory. He can see, in one place, which conversations have taken place, what was explained, and what the client understood. This reduces the chances that something important was left hanging, like a condition of probation the client did not fully grasp, or a deadline that was not clear. It also gives the firm a defensible trail of communication. If questions ever arise about what was said, they are not relying solely on recollection. Coverage changes too. With a hybrid system, the firm is no longer depending on one office manager's personal phone or a short list of freelancers. Attorneys and staff can access AI support from more than one device within preset safeguards. If a jail call comes in late at night, Daniel can get initial clarity using AI interpreting while still planning a follow-up with a human interpreter for sensitive details. If a family member calls with a basic question about where to send a document, staff can answer in the caller's language quickly instead of asking them to call back during limited hours. This does not mean that every situation is perfect. There will still be times when a scheduled human interpreter is the only right choice. But the day-to-day sense of fragility eases. The firm is no longer trying to stretch a few freelancers and bilingual staff across every possible situation. They have a baseline level of access, with human expertise concentrated where it matters most. Client experience becomes more predictable. At Northside, once the hybrid system was in place, Tasha noticed a subtle shift in how multilingual clients moved through the practice. They still saw different interpreters at times. That is natural. But the way they accessed language felt more consistent. When they called, someone could communicate with them quickly. When they had a major conversation, it followed a clear pattern with proper interpretation and a record. When they asked a question, they were less likely to be told to wait until we can find someone to help. Clients did not describe this in technical terms. They just said things like, "They always found a way to talk to me in my language." I never felt like I was bothering them when I had questions. For a criminal defense practice, this mattered. Clients facing serious charges are under pressure. When they also feel unsure whether they are understood, their stress multiplies. When language is handled well, it reduces one of the hidden weights they carry. It is important to say what a robust system is not. It is not a long list of tools that happen to include interpreters and some AI functions. It is not a one-time purchase that can be ignored after setup. It is not a do-it-yourself project assembled over a weekend. Real-world legal workflows are nuanced. Immigration matters have one set of patterns. Personal injury cases follow another. Criminal defense work introduces its own urgent, unpredictable demands. Each area has different high-risk moments, different court expectations, and different client stresses. A robust hybrid system takes those realities into account. It sets rules that match the practice, not a generic call center. It gives staff simple triggers so they are not guessing under pressure. It stores logs and summaries in a way that supports legal work. Not just billing, it evolves over time as the firm notices new edge cases and refines its approach. That is why many firms resist trying to build this alone, even if they could, in theory, piece together separate products. They do not want to become language technology architects. They want language access that feels solid, compliant, and reliable, so they can focus on strategy, advocacy, and preparation. Tasha still has busy days. There are still sudden calls. There are still schedule changes from the court. There are still clients who show up without notice and need help. The difference is that she is no longer holding the entire language operation together with a set of personal systems that only she understands. If she takes a day off, others can follow the same rules and use the same tools. If the firm grows, they do not have to multiply chaos. They can extend a structure that already works. The ad hoc approach was built on effort and improvisation. The robust approach is built on clear decisions, tested workflows, and the right mix of human and AI support. For many firms, the question is not whether their current ad hoc setup is working at all. It is whether they are comfortable carrying the hidden risk and constant coordination it requires. If you want language to shift from a fragile patchwork to a quiet strength in your firm, the next step is simple. Talk with a specialist team that has already designed and refined hybrid systems for legal work, so you can see what a robust, tailored structure would look like for your practice and your caseload. https://cbld.es/me AI Services. Chapter 9. What it is like to implement concrete build AI in your firm. Mark had been looking at the same spreadsheet for 10 minutes when he finally closed his laptop. It showed language services spend for Griffin injury law over the last 12 months. The numbers were not shocking. They were familiar in the worst way. Some months were modest. Some months spiked when a big case went to mediation or trial. There were notes about rush fees, last-minute cancellations, and client-requested different interpreter. The spreadsheet did not show the late nights. It did not show the intake calls Brianna had to reschedule. It did not show the settlement meetings stretched across 3 visits because someone could not get an interpreter on the line. Mark rubbed his eyes and stood up. It was just after 8:30 a.m. The day had not even started, and he already felt behind. He walked down the hall to Brianna's desk. "How many active cases right now need language support?" he asked. She glanced at her screen. "If we count everyone who prefers Spanish, Mandarin, or Arabic as their main language, we are around 40, she said. If we count clients who say they can manage in English but really need help for serious conversations, it is more than that. Doué." Mark nodded. He knew the answer before he asked. He leaned against the edge of her desk. "We have to fix this," he said. "I cannot keep pretending this is just a cost of doing business." Brianna looked at him. "What does fixing it even look like?" she asked. "We tried one vendor, then another. We collect business cards from interpreters. We are still scrambling." Mark paused. "I am going to book a call with Concrete Build," he said. "I want to see if they can help us build an actual system, not another patch." That was day 0. He filled out a short form, picked a time, and added the appointment to his calendar. As the day of the call approached, Mark noticed his own concerns. Time. Would this turn into another long project that went nowhere? He had trials, mediations, and staff meetings. There was never a good time to redesign anything. Staff adoption. Would Brianna and the rest of the team see this as another tool to learn? Would they have to change all of their habits at once? Cost. He was already spending money on interpreters. Would this be another layer of expense with no clear return? He almost rescheduled the call twice, but on the morning of the meeting, he kept it. He closed his office door, opened his notebook, and joined the video call. The person from Concrete Build greeted him, asked a few simple questions about the firm, and then said something that caught his attention. "We are not here to sell you minutes," they said. "We are here to understand how language actually shows up in your practice, and then build around that." Mark felt himself relax a little. This did not sound like another generic vendor pitch. It sounded like a discovery session. That was the start of Phase 1. Phase 1 was discovery and design. Concrete Build did not begin with technology. They began with a map. They asked Mark and Brianna to walk through a typical case at Griffin Injury Law, from the first phone call to the final settlement check. Where does language show up? They asked. Not just when you think of an interpreter, but every time you need to be sure a client understands something important. They moved through the stages slowly. The first contact. Brianna explained how many calls came from family members who spoke better English than the injured client. Sometimes the client was on the line too, silent in the background. Sometimes they were not. The intake appointment. They talked about forms, signed releases, medical records, and fee agreements. They talked about how often clients nodded along, only to call later with basic questions about what they had signed. Ongoing updates. They described status calls, emails, and text messages. They admitted that some information went out in English, only because it was faster. Key decisions. They explored how settlement offers were explained. They talked about the mix of interpreters, family members, and bilingual staff who sometimes helped. Concrete Build wrote it all down. Then they repeated the process for specific case types. Soft tissue cases, catastrophic injuries, cases involving clients with limited literacy in any language. At each point, Concrete Build asked the same simple questions. What is the risk if something is misunderstood here? How often does language slow things down here? What do you do today when you cannot get language support at this step? Mark began to see patterns he had never named. There were certain points where misunderstanding could ruin everything. There were other points where speed mattered more than nuance. There were many more moments where no one had time to arrange a full interpreted session, so nothing happened at all. Out of those patterns, Concrete Build helped them define clear rules. They did not tell Griffin Injury Law what those rules should be. They asked questions until the rules felt obvious. For example, they agreed that high-risk conversations, like settlement explanations and releases, would always involve a human interpreter. Routine appointment reminders and basic updates could be handled with AI-supported language within defined limits. Anytime a client expressed confusion or changed their story, staff would escalate to a human interpreter as soon as possible. They also defined how each rule would show up in practice. Who could trigger AI interpreting? Who could request a human interpreter? How each interaction would be labeled and logged in the case file. By the end of Phase 1, Mark had something he had never seen before. He had a simple, written picture of how language access would work in his firm, matched to his own cases. It was not just a list of features. It was a design. Phase 2 was launch and stabilization. Mark's fear was that this phase would be a heavy lift. He pictured long training sessions. He pictured staff rolling their eyes at another new system. Instead, Concrete Build broke it into steps. First, they held a short session with the people who would use language support the most. For Griffin Injury Law, that meant Brianna at intake, a few paralegals, and one associate attorney, who handled many day-to-day client contacts. They did not walk through a technical manual. They took real scenarios from the week. A new client calling, who speaks only Spanish. A client who needs to reschedule a medical appointment. A case where a demand letter is about to go out, and the attorney wants to confirm that the client understands their role. For each scenario, they showed how to start AI-supported interpreting for quick, low-risk conversations. Request a human interpreter for scheduled, high-stakes calls. Save the notes and summaries in a way that matched Griffin's existing case structure. Staff asked questions like, what if the call starts routine and then suddenly becomes more serious? What if I am not sure whether this is high risk or low risk? What if the client starts talking about something personal that feels sensitive? Concrete Build tied every answer back to the rules they had already agreed on in Phase 1. If it becomes serious, you escalate. If you are unsure, treat it as higher risk. If it is sensitive, bring a human interpreter into the process as soon as possible. Within a week, the team was using the system in small ways every day. Brianna used AI support to handle quick scheduling calls in Spanish and Arabic instead of asking clients to wait. Paralegals used it to confirm addresses, phone numbers, and basic updates. For big conversations, they scheduled human interpreters through the same platform, following the new rules. Concrete Build watched the logs and checked in. They noticed where staff hesitated. They noticed where calls took longer than expected. They noticed where people were still falling back on old habits. Then they made small adjustments. Maybe one rule was not clear enough. Maybe a certain type of call needed to move from the AI allowed category to the human only category. Maybe a reminder needed to be added so staff did not forget to log summaries. This early monitoring and adjustment period turned launch from a stressful go-live event into a steady guided shift. Within a month, Mark could feel a difference. Brianna was not chasing interpreters for every small interaction. Clients were not waiting days for basic answers. The team had fewer last-minute scrambles. They were not finished. But they were out of the old pattern. Phase 3 was optimization and expansion. Once the basics felt natural, Concrete Build and Griffin Injury Law started looking for deeper gains. They pulled real data from the first few months. How many multilingual clients had been served? How many interpreted interactions had taken place? How many of those were AI supported? And how many involved human interpreters? They overlaid that with case outcomes and timelines. Where did matters move faster because language was no longer a bottleneck? Where did staff spend less time coordinating and more time preparing? Where did clients seem more confident about their decisions? They found simple points of leverage. For example, they noticed that cases with early, clear explanations in the client's language were less likely to stall before settlement. They adjusted their rules to encourage a structured, interpreted call early in the case for higher value matters, even if the client seemed fine in English. They also found that some routine calls still took too long when handled case by case. Together, they designed a few standard touchpoints that could be handled through AI-supported language with human backup available. This did not mean more complexity for staff. It meant clearer patterns. On day 10 after intake, we do this. Before sending a demand, we do that. As Griffin Injury Law grew more comfortable, they began to add languages beyond their core set, based on real demand. They also started to think differently about referrals. When other firms asked how they managed such a large multilingual caseload without constant emergency calls, Mark could answer in concrete terms. "We have a hybrid AI plus human interpreting system that fits our practice," he said. "It is not perfect, but it is consistent." While all this was happening at Griffin, other firms were going through similar arcs. At Herrera Immigration Group, Alicia and Luis used Phase 1 to map the most sensitive conversations in their asylum and family-based cases. They identified points where a misinterpreted detail could ruin years of work, and they built those moments into their rules as human only. They also found dozens of low-risk interactions where they had been relying on English only because arranging an interpreter felt like too much. With the hybrid system, staff could offer language support even for those smaller moments without drowning in logistics. At Northside Defense and Trial, Daniel and Tasha used discovery and design to confront their most fragile points. Jail calls, last-minute hearing changes, clients trying to understand plea options under pressure. They set strict rules for those situations. Then, during launch and stabilization, they focused on making it easy for any attorney on duty to trigger the right type of support without needing Tasha to coordinate every time. Over time, Phase 3 at Northside meant refining the system so that late-night calls, sudden schedule changes, and high-stress conversations became more predictable, even if the cases themselves stayed intense. Across all three firms, the pattern was the same. Discovery and design turned a vague frustration into a clear plan. Launch and stabilization translated that plan into daily behavior. Optimization and expansion used real data to make the system stronger over time. By the time a firm reaches this point in the story, another question surfaces. Why bring in Concrete Build at all? Why not try to copy this approach alone or ask an internal team to figure it out? There are a few practical reasons. First, legal-grade focus. Concrete Build is built around medical and legal interpreting. That means the questions they ask, the rules they help you form, And the safeguards they design are shaped by high-stakes work, not general customer service. They are not trying to make every type of business happy. They are tuning for practices where a misinterpreted sentence can have serious consequences. Second, hybrid expertise. Many tools offer either human interpreting or AI-based features. Fewer are designed from the ground up to blend the two in a safe, predictable way. Concrete Build's work is not just about access. It is about deciding, with you, where AI belongs, where it does not, and how the handoff between the two should work so staff are not confused in the moment. Third, speed of deployment. An internal team could, in theory, research products, design rules, and test workflows. In reality, they are already at capacity. Discovery calls with Concrete Build turn what could be a long, unfocused project into a structured process with a clear start, middle, and next step. You get to skip the trial and error of testing random tools and move into refining a framework that has already been proven in similar firms. Fourth, simplicity for staff. Most attorneys and paralegals do not want to think about systems. They want buttons that do what they expect, rules that make sense, and support when something unusual happens. Concrete Build's role is to hide complexity from your team while preserving control for leadership. Staff see a few clear options for triggering language support. Partners see the bigger picture of risk, coverage, and cost. The design work sits between those two levels. In the end, implementing Concrete Build is not about adding a shiny new product to your tech stack. It is about changing how your firm thinks about language access. From a scattered list of contacts to a designed system. From last-minute scrambles to planned, reliable patterns. From guessing about risk to seeing it clearly and managing it. If you can picture what it would feel like for every multilingual client in your practice to have a clear path to understanding, and for your team to have a clear path to supporting them, then you already understand the point of this chapter. The details of your implementation will not match Griffin Injury Law, Herrera Immigration Group, or Northside Defense and Trial. Exactly. Your practice mix is different. Your staff is different. Your clients and courts are different. The process, however, is surprisingly similar. You sit down with someone who knows this space. You map how language really works in your firm. You agree on rules that fit your risk profile and workload. You launch, adjust, and improve with real support. If you want to see what that would look like in your own practice, the simplest next step is a focused conversation. On that call, you can walk through your current approach, see where the biggest gains may be, and get a clear sense of how fast you could move from patchwork to a true hybrid AI plus human system. The call is short. It is practical. It is about your firm, not a generic pitch. If you want language access to become a quiet strength instead of a constant worry, schedule a time to talk with the Concrete Build team and explore what a tailored implementation would look like for you. https://cbld as me AI Services. Chapter 10. Your firm. 90 days after fixing language access. 90 days after they changed how language access worked in their practices. The mornings inside each firm felt different in small but very real ways. At Herrera Immigration Group, Alicia unlocked the office just before 8:30 a.m. She set her bag down, opened her laptop, and pulled up the day's hearings. There were several master calendar hearings with Spanish-speaking clients. There was an individual hearing later that afternoon in a complex asylum case. There was a last-minute bond motion on the docket for the next morning. A year ago, her first thought on a day like this would have been simple and heavy. Will the interpreters show up on time? Now, she looked at the case list and saw clear notes. Language support confirmed for each hearing. Backup options in place. Pre-hearing calls with clients already scheduled with human interpreters. Luis walked in with a coffee and stood in the doorway. "We are set for today," he said. The bond client confirmed yesterday with a human interpreter on the line. He understands the plan. No surprises. Alicia nodded. There was still plenty of work to do. Briefs to finish. Evidence to review. Strategies to refine. But language itself was no longer the wild card that could derail an entire day. Across town, at Griffin Injury Law, Brianna was already on her second intake call of the morning. The first call was from the cousin of a Spanish-speaking client who had been in a car accident. The cousin spoke some English and wanted to handle the details. In the past, Brianna would have tried to manage that conversation in English and hoped nothing important was lost. Now, she followed the firm's normal pattern. She let the cousin explain the basics. Then she said, in a steady voice, that they would take a moment to bring language support onto the call, so the injured client could speak directly if they wished. Within moments, AI-supported interpreting was running for quick clarifications. When the client herself began to describe the pain she felt and the treatment she had received, Brianna tapped to bring in a human interpreter, because this was now a detailed, high-stakes conversation. By the time the call ended, she had a clear picture of the case. The client had heard every question in her own language, and a short summary of the call was already marked for the file. Brianna took a breath. She did not feel rushed. She did not feel that she had cut corners on understanding. Her next call was already ringing. At Northside Defense and Trial, Daniel was in his office reviewing discovery when Tasha knocked on the door. "There is a new jail call request," she said. "Spanish-speaking client. They want to talk before the afternoon hearing." 2 months earlier, a request like that would have meant immediate stress. Who is available? Can we get someone on the line fast enough? Will the call go through before the scheduled time ends? Now, Daniel and Tasha moved through a simple pattern. They checked the case notes. They saw that the client's preferred language was already flagged. They triggered the firm's language support for jail calls, which included immediate AI coverage for basic connection and a human interpreter for the substance of the conversation. Within a short time, Daniel was on the line with the client and a human interpreter, reviewing plea options in clear, plain language. When the call ended, he had a written summary. Not a perfect transcript, but a reliable record of what was explained and how the client responded. He closed the file and looked at Tasha. "We used to go into these hearings half blind," he said. "Now, at least we know what the client believes is happening." Tasha smiled. "We are still busy," she said. "But we are not guessing as much. But we are not guessing." End quote. If you zoom out across these three firms 90 days after fixing language access, a few things stand out. First, there are fewer delays that trace back to misunderstanding or missing interpreters. Hearings still get rescheduled for reasons no one can control. Judges have conflicts. Opposing counsel asks for more time. Clients have emergencies. But the pattern of "we could not move forward because we did not have language support" appears less and less often. At Herrera Immigration Group, Luis counted how many hearings had been delayed in the last quarter for language reasons. The number used to be measured in handfuls each month. Now it was rare enough that each one stood out. Second, there is a visible change in how clients move through decisions. Maria, the Spanish-speaking client with a complex immigration case, no longer nods through explanations and then calls in a panic days later. Ahmed, the Arabic-speaking personal injury client, does not rely entirely on his cousin to interpret settlement offers. He hears them explained by someone trained to handle sensitive, legal conversations. Lynn, the Mandarin-speaking worker in a compensation dispute, has had key documents translated and reviewed in a structured way, instead of through rushed explanations in a mix of languages. When clients understand what is happening, they decide faster and with more confidence. Cases move, not because anyone is pushing harder, but because the basic condition of clear understanding is finally in place. Third, staff time looks different on the calendar. Before, a surprising amount of time disappeared into silent coordination work, chasing interpreters, leaving voicemails, rearranging schedules, explaining to clients why something had to be postponed. Now, much of that time is either eliminated or compressed. Paralegals trigger language support without waiting for a supervisor. Intake specialists handle more of the first contact in a single call. Office managers like Tasha spend less energy patching last-minute gaps and more time refining processes. If you were to take a simple week and count the hours lost to interpreter issues before and after, the difference becomes clear. Imagine a mid-sized firm with 20 active multilingual cases. Before fixing language access, that firm might lose a few hours each week rescheduling calls because language support was not available, a few more hours chasing down freelance interpreters or vendors, entire mornings in court wasted when a hearing could not proceed as planned. It is easy to reach 10 or 15 hours of lost time in a typical week once you include everyone involved. After implementing a hybrid AI plus human system, some of that time remains, because no system can control every outside factor. But the predictable, repeatable parts shrink. The firm can recapture several hours each week that used to vanish into coordination, confusion, and delay. Over a 90-day period, those hours add up to weeks of staff effort that can now be directed to actual casework instead of managing chaos. There is another type of change that is harder to measure, but easy to feel. The emotional baseline inside the firms has shifted. At Herrera Immigration Group, Alicia does not feel that every hearing day is balanced on a knife edge because of language. She still worries about arguments, evidence, and policy changes. Those are part of her work, but she no longer feels that her team is one late interpreter away from losing control of the day. At Griffin Injury Law, Brianna does not end her week drained from running constant interference between clients, family members, and interpreters. She has tools that let her do her job with more direct contact and less improvisation. At Northside Defense and Trial, Daniel and his colleagues feel more confident that what clients believe about their cases is closer to what has actually been explained. They still face hard choices. They still see outcomes that are not ideal. Yet the sense that language itself is an invisible barrier has eased. In each firm, language access has moved from a constant source of friction to a designed part of operations. Not perfect, not effortless, but deliberate. If you pull back even further, you can see why this matters so much to the larger life of the firm. Most firms do not suffer because they lack opportunities. They get calls. They receive referrals. They have plenty of work on their desks. The real threat is losing cases, time, and trust in ways that never show up cleanly on a report. A client who quietly disengages because they never fully understand their options. A hearing that is pushed back, stretching a case out for months longer than needed. A team that spends so much energy managing avoidable problems that they have little left for strategy and preparation. Language access is one of those quiet leverage points. When it is weak, everything else has to work harder. When it is strong, a lot of other efforts begin to produce better results without any new marketing campaign or dramatic change. 90 days after fixing language access, firms like Herrera Immigration Group, Griffin Injury Law, and Northside Defense and Trial are not transformed into something unrecognizable. They are the same firms, with the same practice areas, the same people, and many of the same challenges. The difference is that one of the most important and previously unstable parts of their work now rests on a solid foundation. Every multilingual client can be understood quickly and clearly. Attorneys have more confidence that nothing vital is lost in translation. Staff can support that process without burning out or guessing. That is what you are really buying when you invest in a hybrid AI plus human interpreting system that is built for legal work and tuned for your practice. You are buying fewer hidden risks, fewer invisible costs, and more control over how your cases move. At this point, there are two simple paths in front of any firm that has read this far. Path A is to keep doing what you are doing. You continue using a mix of legacy vendors, ad hoc interpreters, bilingual staff, and family members. You will still win cases. You will still serve clients. But you will also keep absorbing small delays and quiet risks that never quite rise to the level of a crisis, yet never go away. You will keep wondering whether that client really understood. You will keep rescheduling the occasional hearing for reasons you do not fully control. You will keep spending money on language services without a clear sense of return. Path B is to treat language access as a core system, not a loose collection of contacts and improvisations. You decide that it deserves the same level of design and care you give to your case management, your trust accounting, or your trial preparation. You install a hybrid AI plus human interpreting and translation system that fits your firm with clear rules, clear workflows, and clear accountability. You still encounter hard cases and difficult decisions. However, language itself stops being one of the reasons you lose time, leverage, or trust. If you lean toward path B, the natural next question is what happens when you book a call with Concrete Build? It is not a commitment to overhaul your entire practice. It is a structured conversation with someone who has seen these patterns across many firms and can help you see them clearly in your own. On that call, a Concrete Build specialist will listen to how your firm actually works today, not an idealized version. Learn your practice mix, your client languages, and your most common pressure points. Help you estimate the impact of fixing language access in concrete terms based on your caseload. Outline the simplest, safest starting point for a hybrid system in your environment. They will not ask you to become a technology expert. They will not push you into a one-size-fits-all template. The goal of the call is clarity first, decision second. You can leave that conversation with a better understanding of where language helps you, where it hurts you, and what a realistic path forward looks like. From there, you can decide whether it makes sense to move ahead with Concrete Build, adapt some of the thinking on your own, or revisit the question later. The point is that you will be making that choice with open eyes. You have seen what language gaps cost. You have seen how a hybrid AI plus human system changes daily life inside real firms. You have seen how much difference 90 days of deliberate focus can make. The future where every multilingual client in your practice can understand you clearly and where your team can support them without constant stress is not distant or abstract. It is one decision away. If you want to explore how to turn language access from a recurring problem into a quiet strength in your own firm, schedule a time to speak with Concrete Build and see what a tailored implementation would look like for you. https://cbld as-me AI-services